thank you to everybody who has joined us. We will also be sharing this presentation in the group, so people who can't attend live will get the benefit of Prue's wisdom. I'm not going to say very much during this presentation because Prue has given up her time and we want to get our bang for our buck from her. So Prue, before you launch into the topic, I would love it if you could just give everyone a little bit of background about your role at the uni, your role with this research and how you even got into it.
Oh, okay. Well, I've been at UNSW Law School for a very long time, possibly too long to mention, and I was teaching succession, and it became clear to me after a while that there were real issues for Indigenous people, that our mainstream succession law was causing terrible problems for them, and that nobody seemed to be doing anything about it or paying any attention. And so over the last 20 years or so, I have written many articles, a book, and gone and visited a whole bunch of Aboriginal communities to ask them what were their concerns, because it was obviously it wasn't a good idea to just march in and say, hey, I know what should happen to you, you know, what should happen. So I actually went round communities in New South Wales, that was all the funding that I had, and asked Aboriginal people what were their big concerns. And they weren't actually necessarily the ones that I thought would be the concerns. And eventually came up with the sorts of things I'm going to talk to you about. And because I was working with Indigenous people and thinking about the culturally appropriate will thing, I also thought a bit about cultural appropriate wills for other people in Australia. And so that's always been part of my teaching in my succession course.
Wow. I mean, it's such a undiscovered area in the sense that, you know, I feel like none of the training, so I've been doing succession for about 10 years, which is still, you know, not that long, but in that whole time, this has never come up. Not at uni, not at any of the, you know, the big national estate planning conferences. Like, it's such, you know, we just basically ignore it. And in a profession, you know, largely dominated by like Caucasian,
yes,
fairly privileged people, you know, it's so, it just needs so much attention that we're not giving it. So on that note, I will shut up and let you share your thoughts.
Okay, well, thank you very much, Tara, and thank you to all of you for being interested in this topic, which is, as you will be aware now, is something that of a passion of mine. I'm going to start by talking about issues for Indigenous people, and then if there's time, I'll talk about some other cultural groups. But I think one of the things to point out here is that what's really important is for us to know what we don't know. And if we don't know what we don't know, we're in real trouble in this area, because the ability to question your own assumptions and the ability to say to yourself, oh, I'm not sure whether that's going to work, is obviously a critical part of the armoury of any succession lawyer, as you all know. And this is one of the areas where our assumptions can trip us up. And so part of what I'm going to do today is to sort of try to map out the landscape a little bit so that you can see how this works. Can I say click and then you move to the next slide? Right, so click.
Okay, sorry, I'm making that work. How's that?
Oh, there, done.
Great.
Okay.
And I should say, guys, for the attendees watching, there's a chat box. Throw your questions up in the chat box, and then we'll try and make sure Prue has time to answer them at the end.
Great. So this is a flyer that we used when I was going around Aboriginal communities in New South Wales, and it just, it was actually the result of some of the research, as well as being used to help us to develop pro bono work that was going on in relation to Aboriginal people. And I just want to put it in here because some of the things that we discovered were important in will drafting. The real really big one was disputes about where and how to bury a body. And then there are, of course, the kinship issues and some of the things about customary law and secret knowledge. So if we go to the next slide now, some of the issues for us Indigenous people that are really important for wills are, first of all, and this is the one that is usually most obvious to people, the fact that there are different kinship rules that, that mean that the law of succession, which says certain words mean certain things, doesn't necessarily apply properly to Indigenous people. The second really big one is death and disposal of the body, because in every single Aboriginal community that I visited, there had been a major burial dispute. And those major burial disputes had often severed a community for 30, 40 years. And so as soon as people found out that you can appoint an executor and the executor has the authority to deal with the body, almost in every place I went, they said, "Can you make me a will now?" So it was that important. The other thing is, of course, that if there's any Aboriginal customary law issues, the wonderful thing about wills is that you can incorporate that into your individual statement of wishes of the person. And of course, you can also do this with groups, you know, like Islamic groups, or, you know, somebody who's from Italy or Malta or whatever. So that's the wonderful thing about a will. And it was the thing that made the Aboriginal participants in my study willing to consider what they thought of as whitefellow law. So that was actually important. A fourth thing that's really important and that people are not necessarily aware of is that there is a very rapidly developing middle class in our Indigenous communities. So one of the things that most people don't know, and certainly if you're not in New South Wales, you're unlikely to know this, the majority of First Nations people in Australia live in the Campbelltown, Macarthur area of Sydney. And a large proportion of those are middle class. So this means that they have all the same issues as everybody else who's middle class and so on, and will be interested in having wills made and so on, but they will also continue to have many of the issues that are important for making customarily appropriate wills, because most Aboriginal people in Australia continue to have links and obligations that come out of customary law, even if they're living next door to you or me in a major capital city. So, and this is something that people often forget and aren't really aware of. So that's important. The last thing is, and can we go to the next slide for this, is that Australia is actually, for Indigenous people in Australia, Australia is a land of many nations. And if you look at the number of nations, so that's about 300 there in an area larger than the size of Europe. If you're talking about one Indigenous nation and another Indigenous nation, it is completely unreasonable to expect them to be the same. Just as we don't expect the law of succession to be the same in France and Germany, we can't expect the same to be between these different groups. And that's one of the reasons that we have not actually been able to draft intestacy legislation for Indigenous people in a way that actually directs what to do. It's because every group is so different. So that's actually really important. The next slide shows the New South Wales groups. Again, it's a big group. And the really big point, I've just emphasised New South Wales here because I'm in New South Wales, but the really big point is that all these are nations and they have different views. And although there are some common patterns, they are not the same in every group. So you can't just say, you're Indigenous, therefore you'll have this kind of kinship pattern, or you'll have this kind of obligation, and so on. Okay, so let's move on to the next one and think about kinship. So if we think about how our own succession law works, we actually decide that people owe obligations to each other on the basis of their kinship. So we expect a mother to look after children. We expect parents to care for their children and look after them and so on, and family provision is based on this. This pattern is clear across all communities. So when we think of the kinship structures in Indigenous systems, it's obviously they are going to lead to the obligations that one would expect to see in the will or in the succession law that is going to apply. So just to see how different it can be in some other groups, the next two slides actually talk about these relationships. This first slide, if you can see it clearly, you'll see that this is actually my family. So there's me in the middle there, ME. I'm female and I have a spouse. The males have triangles here and the females have circles. And you will see that I have 3 children, and then I have beyond that family, beyond that family, I then have nieces and nephews who are the children of my siblings. And you will also see that I have 1 father, 1 spouse, 1 grandfather, and so on. So that is familiar to all of us because this is actually the pattern of kinship that the common law of succession is based on. So now, the next slide is exactly the same bloodline pattern. So there's me still in the middle, but just have a look at how many children I have. Suddenly I've got 5. How did that happen? Well, this is quite a common pattern in Indigenous groups where I have a same-sex sibling and they have children. It is very common for those children to be regarded as the children of both the same-sex siblings. So people who our law would regard as nieces and nephews are regarded as children. And I think just looking at this alone, you can see how much trouble it will cause if you draft a will which says, I give this to my children, and you are not clear about exactly who those children are. So that's one thing. The other thing you might see is that I have more than 1 father. I also have more than 1 husband. And this is something that usually makes people really twitchy. So in relation to my husband, there's only 1 husband that I'm supposed to be able to sleep with and so on. But the other spouses, the other husbands and so on, I have a number of obligations to which match the obligations for the husband, but they are not, but they don't involve the sexual relationship. So it's all the rest of it, all the rest of those obligations remain. The fact that there are multiple people in different generations having this also reflects the fact that in many Aboriginal kinship, ways of thinking about kinship, time is not seen as we see it, that is starting in the far distant past and coming down to the future in a long line. It's seen as a circle and it goes round and round. So there's a very different way of thinking about it. So just coming back to that point that kinship creates obligation, it's really important to be able to look at the kinship and work out who you should be looking at. So if we look at the next slide, it's about drafting to deal with these kinship issues. So I've put a reference there to the Aboriginal Wills Handbook. I'll just give you state a word about this. The Aboriginal Wills Handbook is the result of constant requests from the Aboriginal Legal Service to me whenever I write an article to develop something like this, to have precedents so that lawyers would find it relatively easy to deal with this. So I developed this for the Trustee and Guardian of New South Wales. It's a free resource. And the idea is that an Aboriginal person or an Indigenous person elsewhere can take the book, fill in bits of it themselves, and then take the whole book with what they've filled in to a lawyer who can then do relevant drafting. It isn't a complete book of precedent. It's really based on precedents. It's based on assuming that you'll be using other precedents such as Hutley or something like that. And it just picks out the specific things that are issues for Indigenous people for this purpose. It's also based on the law of New South Wales. So, but of course, lawyers all over Australia will find it relatively easy to just substitute their own legislation for this particular matter. Okay, so when you're taking instructions, it's useful to ask questions like, do you consider yourself to be the parent, the brother or so of X? Ask people to draw a family tree, to tease out blood and non-blood relatives, and determine exactly who's meant by the classifications. I think that one thing that's quite useful is to put in a beneficiary identification clause in a will like this to make sure that it's clear who you're talking about, and to avoid class gifts if you can, because the problem of the determination of the class is so great in relation to a different kinship group. So just trying to be really clear, using names if at all possible, and so on. With guardianship and so on, again, using names rather than classes, it's often less of an issue with guardianship. And of course, you will need to advise, well, both Indigenous and non-Indigenous clients, as you do, that this is not binding, but might be persuasive. That's important because people often don't really understand how the law works. So the importance of guardianship, I think it's really important. I think it's useful to have it in a will, even if it isn't binding, because it does make it easier for a court to do that determination. Anyway, moving on to the next slide. So death and disposal issues are really important. So one of the things that you might have noticed is that in the disputes that go to court about death and burial, almost 70% of them involve Indigenous people. Now that is a massive disproportion, considering that the population of Indigenous people is around 2 to 3%. So death and disposal of the body issues are extraordinarily important. And this means that the appointment of an executor for Indigenous people needs to be a person who will carry out their wishes in respect of disposal of the body and the funeral. Now, I know that Victoria has proposed, and the Law Reform Commission has proposed a different way of doing this, but that hasn't actually, that being a declaration that somebody else is going to be the person in charge of disposing of the body. But that hasn't come into law yet, and may never. And in the meantime, the appointment of the executor is possibly more important for Indigenous clients than it is for anybody else. And so the client needs to be advised that they need to be really sure that the person they appoint as executor will not only do what they want with the estate, but also will do what they want with the body. So, of course, most of these funeral and burial disputes that have gone to court have been of Indigenous people who died intestate. One of the things that is happening is that the rate of use of wills in the Aboriginal and Indigenous community is going up. So about 10 years ago, it seemed to be about 6%. It's moving up, and we may be approaching about 20% so far. There's a long way to go, but there has been a big change. So the next slide just talks about drafting to deal with these issues. So one of the things to consider, apart from thinking about alternative executors and whether they also need to be agreeable, is to consider having a must consult clause in respect of the disposal of a body, particularly if they want to choose an executor who is not necessarily Indigenous or is not necessarily a person they think will necessarily follow their instructions otherwise. That is something. So New South Wales Trustee and Guardian has a must consult clause in their wills for this purpose, because of course they only do wills, so they're changing where they are appointed as executor. So it's this must consult clause that I think is a reasonable idea. The next thing is a bit more esoteric. So passing secret information is quite an important issue for people who look at Aboriginal society and aren't familiar with Aboriginal society. One of the things that is extremely important in Aboriginal society is secrecy. So it's the easiest way to explain it, I think, is to say that it's as if when you went to primary school, you weren't allowed to know that year 6 existed until you were in year 3. So if you were in year 1, you wouldn't even know that year 6 exists. This means that sometimes people who one would expect to know things, namely Indigenous people, simply are not aware of something because they're not considered to be qualified. So protecting secrecy is important to many Aboriginal people. Sometimes the simplest way to deal with this is the best. So just, put the information in a sealed envelope, make that envelope not to be opened until the event of my death. That is simple, it's fairly clear, everybody understands it. Otherwise, you might consider in relation to, for example, you might suggest a half-secret trust or sometimes a secret trust. I personally prefer the use of half-secret trusts because it's clear that there is something in the will, whereas if you have a fully secret trust, there'll be nothing in the will to show that that exists. And so I suggest that it's a good idea if you think this is something to be used, that to set up a half-secret trust. And the book has examples of letters that would be used to set up a half-secret trust, and the clause in the will, you know, pretty straightforward as a way of dealing with this.
Prue, do you mind if I interject with a question?
Not at all.
So, and I must say my knowledge about Indigenous culture is very limited, but I have heard before that a lot of their information and traditions are passed on orally, not written down. So in terms of, are you sort of saying the half-secret trust, they would already have this information written, or as part of the will exercise, they have to take the next step and write it down?
So what I'm suggesting is that this would be very much a secondary thing for them given that the oral process that they should have used would have failed. So one of the things that might happen is, let's say you're dealing with somebody who has information and it is supposed to be given to their nephew, but it's only supposed to be given to their nephew when the nephew has established that they know X or have done X. In that situation, they normally wouldn't tell it to the nephew until the nephew had done X. The thing is, of course, that there's a danger that they'll get run over by a bus before that happens. So many Indigenous people would what they'd want to do is use the oral system, and this is just a backup if they're afraid that they will die before they can actually do the normal passing on that they would do. Does that answer the question?
Yeah, I think it does. And so, like, I often get my clients to do a letter of wishes, which is, you know, mentioning just things that they want to, you know, add toward or to expand the sort of like strict legal framework of the will. And they go, great idea, yep. And then they drag their heels on actually drafting it. So I can imagine in this case there could be similar. So the onus is on us as advisors to really follow up and make sure that they actually follow through and do it.
Well, I actually think that it might be that you have to just leave that to them. They can't, if they haven't done it, you cannot establish a half-secret trust because it needs to be established before the will is made. So,
yeah, okay, so you tell them to do it.
So you have to tell them to do it, and you say, look, if you don't do it, then I'll have to do the will without it.
Yeah.
So I see this very much as a backup provision, not as the first provision for dealing with these ritual issues or customary law issues, because customary law is an oral tradition, and when it's all working properly, the problem is that we've had so many problems with so much breakdown in Aboriginal community of traditional patterns, and what's left is extra precious because of that. And, you know, if you're not living a totally traditional life, as hardly anybody is in New South Wales or Victoria, though that's not so true in Queensland, not so true in the Northern Territory or Northern Western Australia. There is this possibility that you might need this sort of backup plan. So I don't think this is the first thing to be put forward for anybody. It's just, yeah, I hope you can't hear that. I think that is that is somebody cold calling me and I'm ignoring it.
That's okay. We have another question come through, and I'm mindful of disturbing your flow. So you are welcome to say you'll answer it at the end. But Jacinta has asked about that must consult clause with the executors. So is there much to it that, you know, do we have to overcomplicate it, or is it pretty simple?
I think you should write wills in a really straightforward way. So if you will see there is a must consult clause in the Aboriginal Wills Handbook.
Oh yeah, great.
Just so there is actually a clause in there. That's one of the things that is in there. and it just seems to me that that's it's a reasonably easy way to deal with some of those issues without actually making anything extra complicated.
Perfect. I will get that handbook and put it in the group so everyone can have a look at that example.
Okay, so we want to go to the next one, which is about artwork, I think. Yeah. So, yeah, artwork. So, artwork, if there isn't very much artwork, the person isn't actually a professional artist, then I think you can deal with this. But I would urge people, if you're dealing with a person who's a professional artist, you know, who does heaps of art, that it is worth going to the Arts Law Centre of Australia. And I saw on your website that you have referred to Artists in the Black, which is part of the Arts Law Centre. That's a really good, they really know what they're doing. I would use their advice. I think that's a specialist area, and so I don't want to say any much more about it now. Okay, so just my next one is just a couple of things. There are things in the Aboriginal Wills Handbook, such as a clause for saying that you don't want your name or photograph used after you're dead, and things like that. Just like everything else, not every Indigenous person has that rule. So some groups will be perfectly happy for their names to be mentioned, their photos to be passed around. Other groups won't want either or one or the other. So it is very much a case of working out what's culturally appropriate for this person in their cultural group. And this is just a couple of pieces that explain the research that I did on this. One thing I haven't mentioned at the moment is, of course, that in New South Wales and Tasmania, there's a special provision for using Aboriginal customary law on intestacy where the deceased is an Aboriginal or Indigenous person. That is something that came into the law quite some time ago, but New South Wales has had 3 or 4 cases now, and so it's worth having a look at those. Probably they're mentioned in in a couple of one of these articles. So if you're dealing with intestate Aboriginal clients in New South Wales or Tasmania, there is actually a provision for importing customary law, which isn't available elsewhere. It would, I think, though, of course, Northern Territory. This provision is based on the Northern Territory's provision, but unfortunately the Northern Territory provision suffers from some defects which mean that it is not actually usable by most traditional Aboriginal people. So I think the Northern Territory needs to change to the system New South Wales and Tasmania's got, and everybody else needs to hassle their Attorney General into bringing this provision into their Succession Act or relevant will intestacy provision. Okay, so I just thought I'd say a few words about other cultural groups. So just it's worth having a look at this fact. Here are the top countries of birth in Australia for 2008, 2013 and 2018. These come from the Bureau of Statistics. So one group that we have no difficulty with is, of these, England, Scotland at either end of the table, and New Zealand, we don't have very much difficulty with. It's very straightforward, very similar to ours. Although, of course, there are some issues about, for example, tax law with respect to England, that the UK, that's worth thinking about at times. If someone wants to ask about that, I can talk about it. But the thing to notice is, what really matters for drafting wills is, of course, what the median age of that population is. So because in Australia we have a really quite high rate of will making, and in fact it's probably around 90% in people over the age of 40. This is spectacular compared to almost every other country in the world. But of course younger people don't do it. If you talk about it as 18 plus, then it's probably about 60%. But given if you go to the next one, we look at the median age of our migrant populations. Yeah, and you see, looking at 2018, you'll see that, for example, in England, the people who were born in England, their average age is about 57. People from Latvia, 77. Italy, 71. Vietnam, 46. So a number of groups have relatively young populations and are less likely to be getting wills drafted. And those who have people over the age of 40, they're the ones who are really likely to be in this group. So I thought I'd just talk a little bit about Italy, and talking about cultural background, and a little bit about Islamic law, because that group is just beginning to start to come into people's offices and ask for wills that are appropriate. And that is actually a really interesting area. So Italy, I'm just talking about Italy because it's a civil law system, and there are a lot of Italians in Australia. Mostly they're perfectly happy to have the Australian law apply, but one of the really major differences is, of course, that in Italy there's a use of codes, and they are a forced succession jurisdiction. If people have grown up in a forced succession jurisdiction, they may not think about wills very much at all, and they may just assume that intestacy is what will happen, because in Italy you're not allowed to make a will about more than a third of your estate. So that means that in Italy people often don't make wills at all, and the whole property goes on the forced succession pattern. The other thing in Italy is, of course, that they don't have a system where the person dies and then there's a process of getting probate, and then after the executor has distributed the property, then the heir takes the property. So it's immediate passing in the Italian system, and it means sometimes the immediate passing means that there are situations where the heir might inherit the debts as well as the assets, and so there are a number of ways of dealing with that. The most common being a specification by the heir that he will take the property, but take it on benefit of inventory, which means that he's actually specified which assets he or she is going to take. So the intestacy regime in Italy is basically goes through spouse down to descendants, then to ascendants, parents and grandparents and so on, brothers and sisters and other relatives to the 6th degree, and then to the state. They do have wills. I'm going to talk about that a little bit more in a minute, I think. No, maybe I should talk about it now. So they have holographic wills, which is a will that we don't recognise in Australia, but where it's been written wholly in the handwriting of the deceased and signed by them and dated by them. In Italy, a signature on a will must be your forename and your surname. It can't just be any signature or initials, things like that. So there are some very strict rules that we don't have to deal with. Most people will get a will, either they will make a holographic will because that is cheap, or they will go to a notary, and a notary will make the will, and that can be a public will or a secret will. The great advantage of a public will is that it can't really be overturned except in the case of fraud. So it's a very powerful form of instrument. And the Italians also still have quite a few of the privileged wills, the military will, the will made on aircraft, on deck ship, etc., etc. They still have that in a way that we don't. So if somebody comes into your office who has an Italian background, they're going to be thinking about things like that. They may well expect you to act like a notary. That's reasonably easy to deal with, but they might have a very strong idea of who should be entitled, which makes it easy because they don't get confused about who's going to get what. So just moving to the Islamic law sources. Look, this is a really complicated thing, but just very briefly, the major two sources in Islamic law are the Quran, which is regarded as a direct revelation of God, and then the Sunnah. The Sunnah are a collection of traditions which come from the Hadith, the sayings and deeds and implications made by the prophet. Those sunnah are collected and are very important. Inheritance is regarded as extremely important in Islamic law, and so and it's incredibly complicated because of the fractional systems that they used. Going to the next one, what really matters when you're dealing with Islamic people is which school they're coming from. So the Shia is the school that we hear about a lot as very radical and so on. In terms of succession, it's much better to be a Shia woman than a Sunni woman. And up to the 19th century, it would have been much better to be a Shia woman than a Western Christian woman in terms of the property inheritance that you would get. Going to the next slide, you can see this is the distribution of different schools. So one of the things to notice here is that Hanafi is one of the most significant. And so if you're dealing with people from India, Pakistan, Afghanistan, and so on, that will be the Hanafi. But Hanbali includes groups like Saudi Arabia, Kuwait, Qatar, and they have a very restrictive view of what can be done. The group around Indonesia, Africa, and Malaysia, they are Shafi, and they have a relatively relaxed view of sources, only relatively, but it's worth recognising that. I've given you some bibliography to sort of help with this in case you need it. Thinking in terms of relationships, if we look at Italy, you'll see that in Italy they're not yet, or they weren't last year. They haven't yet recognised same-sex marriage, I don't think. I just need to check how up-to-date that is. But there is no recognition of cohabitants generally, so de facto is no. The one thing they have done is in 2012, they regularised the status of children so that extramarital children are the same as marital children. They have some restrictions on adoption in that if you're adopted after the age of 18, then you're not entitled to inherit from your adoptive parents. I find that an interesting little wrinkle. So their views of families, it's a relatively conservative, I suppose it's a Catholic country and you wouldn't be surprised that it's relatively conservative. Looking at the Islamic position, relationships in Islam, as we all know, spouses may be multiple, but there's no recognition of de facto or same-sex marriage. Children of the marriage only will be recognised on inheritance. Adoption is not recognised except in a few countries which have developed a code to deal with these issues. The extent of the family which can inherit is much more extensive for the Sunni than the Shia. And of course, the Sunni give much more preference to males than the Shia do. One thing that I should have mentioned in relation to Italy is the importance of the matrimonial property regime. So most of the civilian systems have some form of matrimonial property. This is problematic for us in that if you go and you look at a succession law textbook in one of those countries, they won't mention matrimonial property and you'll think, oh, the spouse isn't getting anything, or the spouse is getting very little. Whereas in actual fact, if the matrimonial property regime is in place, all property acquired after the marriage will belong to the spouses, and so if one of them dies, the other one will get that, unless there is a prenuptial agreement, a contract, and so big question for Italy and for other civil law countries also always about whether there's a matrimonial property regime in place for the spouses. Okay, I hope you can see this is really very much just to sort of skip over the top. Can't possibly talk about this in great detail. And can we then?
That's fine, Prue. I mean, I guess this is really just to let us know the extent of what we don't know so we can make further inquiry.
Yeah. So moving on to the next one, which is there's a slide about intestacy and forced heirship. Yeah. So just looking at this, because both Italy and Islamic law have really strict limits on testamentary freedom. They are similar in that way. In Italy, generally you can't make a will about more than a third of the estate unless there's no spouse, in which case you might be able to make a will about half the estate. I've already talked about how that went to the 6th degree, and I've talked about the matrimonial property, although Italy itself is less focused on, has less matrimonial property than some other civil systems. In Islamic law, there are very, very complex fractions of the estate that the Quran sets out as required to give to particular people, and it makes a difference whether somebody is a uterine or a consanguine sister, for example, that is sister of the same mother and different fathers, or sister of the same father or not. Obviously, if you have a system that recognises multiple wives, then you have to deal with the fact that children will be half siblings and so on. And so the fractions all are worked out according to those relationships in a really detailed way. Now, we all know that sons normally get double what daughters get. But one of the things that's really important to think about is that there is also a rule that the sons must look after the daughters and the females in their families, and they're actually supposed to do that beyond their inheritance and into their own property. That is actually from the Quran. Now, in Shafi law, it doesn't seem to be taken much notice of. So in Indonesia and Malaysia, it seems to be kind of ignored. But in the other places, this view that if you give property to a wife or to a daughter or a son's daughter, that daughter is allowed to fritter it away. She doesn't have to look after anybody else with it, while the sons do have to look after the female relatives with it. So although women don't get much control on Islamic law, they do get looked after. So that's actually quite an important thing to know about this. And it means that when you're drafting, you might actually reflect the Quranic law better by creating a trust that where sons look after daughters than necessarily by doing the double thing. So that's something to think about. The other thing this is a thing that I love, is that there is this phenomenon, especially in countries like Egypt and Iran, where fathers who only have daughters and who therefore, this is for Sunni fathers who only have daughters and therefore whose daughters are going to be knocked out of the succession by the father's brother or something, will convert to Shia very close before they die. And they do this because under the Shia law, the daughter will come first. And that conversion means that the daughter is protected. That there is no actual doctrine of heresy in Islamic law, despite what the Islamic State have tried to tell people. So this conversion from Sunni to Shia in order to protect daughters is a well-recognised phenomenon. And so there are situations where people will know this. Now, of course, as with Australians who come into your office and say, I want a will, they don't know very much about their own law. The same will often apply to your Islamic clients, your Italian clients, your whatever. So it's not necessary always for you to do the exact translation of some particular Islamic law or some particular Italian law. It may be that you can think about some of these principles and talk to your client and come up with something that will still get through family provision and where it will work for everybody in the way that you normally do. So my last slide, apart from the bibliography, is about what to do. So obviously, you can't be expert on every one of these different, sorry about that. I don't know if you can hear that phone ringing.
Oh, it's fine. It's very faint.
Okay, all right, good. So obviously you can't know an enormous amount about all of these systems. That, you know, it's a lifetime's work for us to deal with our own system most of the time. but you can have a basic understanding of some of the points in the background, like, is there a matrimonial property law that I need to think about? Is there some special rule about how you deal with women and men that I need to think about? And look for places where you could answer your questions. There are people, people are drafting Islamic wills that match the shares for a particular Sunni group or a particular Shia group. It is difficult, but it is difficult if you don't know anything about it, but one of the books in the bibliography I've given you actually sets that out. And of course, this is, so far what I've really been talking about is what you do when you're dealing with people who live in Australia, have their families in Australia now, and want something that's culturally appropriate and will work for them in Australia. Of course, there is also the issue of making wills which apply for your Australian client, but who owns land in Italy or whatever. Of course, you need to know things like your Italian person, you might be making a will to apply in Italy, but if so, your client needs to know that it can't operate on a certain proportion of the land, a present proportion of the estate, and so on. So some of those things are important, and of course I'm leaving aside all the conflicts of laws issues at the moment as well. And of course the number two here, but really number one, is no, you don't know too much, and try to find the sources that are really useful. And a lot of being willing to listen, being alert to the fact that your assumptions might not be quite right for this particular cultural background. And yes, certainly, just responding to this question, working out how to match that with the need to deal with family provision and family maintenance and so on, does make this complex, but it's certainly not, it's not so difficult that it shouldn't be attempted. And it means that asking people in your initial instructions about their cultural background may be something you want to do. Certainly, I think you ought to be asking people whether they're Indigenous or not, and then asking them whether they want particular things to do with their Indigenous heritage addressed in the will or not. Yeah, so thank you very much for listening to this, and now I'm happy to answer some questions if you would like me to.
Thank you so much, Prue. That has totally exceeded my expectations. It's so fascinating, and learnt so much today. I do have a question while we're just checking if anyone else has questions to put up in the chat. And I don't know, it's not really a question, but I'd like to sort of hear your thoughts on this. You mentioned when we were chatting the other day about the interaction between the family provision application rules that we have and the obligations attaching to the inheritance, particularly in the Muslim culture, where, you know, a son might receive double, but that is attached, that has obligations attached to it. Have there been many cases where that has been analysed, or?
There are a very few. There was one in the ACT a few years ago where a will was drafted for, which gave double shares to the sons and single shares to the daughters. And the daughters, having grown up in Australia, were deeply unhappy, and they made a family provision claim. And that is something that's real. So just because your client is deeply traditional does not mean that their children are. So it is important to talk to them about the possibility that if they do it the way they want, that there will be a family provision claim. And therefore to suggest that perhaps, that's why I mentioned the rule about that men are supposed to look after the women. And so you might say, well, you know, it might be less likely to breach the family provision, you know, to be seen as a real breach of family provision, though it's still not guaranteed. If you, for example, gave a portion equally to the son and daughter, and then another portion to the son on trust for the daughter.
Yeah.
Some wouldn't like it.
No, well, I mean, it is like a compromise, I suppose, because,
yeah,
you know, when you explain, well, you know, would you like your estate eroded by litigation lawyers? which is what's going to happen, then this is, this is not such a bad alternative.
Yeah.
And I mean,
talking to them about, we need to do this as culturally appropriate as we can for you, what you want, but this also has to meet the law of Australia. Yeah. And Australian law does not take the view that sons should get twice as much as daughters. So find some kind of compromise. And of course, I think your idea that we should give, of getting people to have a statement about their wishes is actually really useful. It's not binding, but it doesn't matter. In many cases, people will try to do what their parent or whoever it was said were their wishes.
Yeah. And Christiana, thank you for your comment about the difficulty of the challenges and family provision applications when a person has those set views. I hope that sort of gives you some ideas. We've got another question from Jacinta. So Jacinta is an estate planning lawyer. She gets a lot of clients who still receive the Italian pension and the Australian pension. And I don't know if this, you feel free to say this isn't something you've ever looked at, but if you have, is there any further investigation on this where there's only a pension from Italy and no other assets in Italy?
I have to say that I really know nothing about Italian pensions, but it does seem to me that in situations like where you're dealing with two different countries, it's often better to make two different wills.
Yeah.
It's so complicated. The rules of jurisdiction are such that it can be really complicated. So if you want to do something with the child, I have no idea, for example, whether an Italian pension will die with the person. I mean, maybe the spousal pensions don't. So I think better to deal with that separately, deal with the Australian assets separately, because it will be simpler in terms of getting jurisdiction to deal with the assets.
Yeah, yeah. Or limit the will to the Australian assets only and then send them off to an Italian lawyer. And yeah.
And of course, because the world is smaller than it used to be, there are people who do lots of, there are quite a lot of Australian lawyers who have a lawyer in Italy that they constantly use to. I tell you, Italy seems to be a country full of succession lawyers. I've never seen so many in my life. I love it. I'm going to Italy again in a couple of weeks to work on Italian succession law.
Oh, gorgeous.
Somebody's got to do it. But it is, honestly, seem to be more succession lawyers there than in any other jurisdiction.
I mean, it's actually fascinating because they have such a long history of intergenerational wealth transfer as well. So, I feel like as Australia develops and grows up, that we'll have a lot to learn from some of these European countries.
Yeah, and the more we know about each other, the better, really, just generally.
Yeah. Well, I think that's the last call for questions. Prue, you've been more than generous with your time, so thank you so much for sharing this. I will have a recording that will go up in the group so everyone else who couldn't attend live will get the benefit of it. Just in terms of sort of practical, do you consult or practice in this area or just through your academia now?
I only act as academic. I don't mind, if somebody wants to ring me and have a bit of a chat, that's fine. Obviously, I can't spend all day doing that. I do have some other things to do. But no, I don't consult formally. So okay. I'm happy to talk to people for nothing, for not too long.
Thank you. That's so generous. And you've given us a lot of resources in the bibliographies to get us started and really just sort of start all of us thinking a little bit outside of the box and being aware of the prejudice that we all bring from our unique backgrounds when dealing with clients. So it's tremendously valuable, and thank you so much on behalf of everybody.
Thank you. It was my very great pleasure.
We have a great afternoon now.
Okay, bye-bye.
Bye.
Okay.